Hi, we're talking about Your Money Matters, and my name is Alex Matthew. This is NDTV Profit, of course. And on this show, we speak about everything money related. Today, I'd like to talk about a new trend where more and more people are veering towards the trust structure when they're thinking about intergenerational wealth and how to transfer it to the next generation. Of course, there's the will. And a lot of people are now writing wills, which is a positive move, of course. We'll talk about how a trust structure compares with a will and whether you should even contemplate giving away some of your assets before the end. Joining me for this conversation is Yashasvi Kadakia, who is a partner at Cyril Amarchand Mangaldas. Thank you so much, Yashasvi, for taking the time. Let me ask about this first. Why are more people going for that trust structure? What stands out about it?
So funnily and fascinatingly, Alex, the trust structure concept in India has existed for more than 140 years, and very few people know that. But you're right that there is a renewed interest in relation to trusts over the last decade or so. I think this is for various reasons. One is, of course, there is more knowledge. Nothing really about trusts has changed over the last 10 years or so, but there is increasingly more knowledge. We have imported a lot of best practices that exist in offshore countries into India. Clients that we know have also made more wealth and are now having more sophisticated assets for which they're thinking of more sophisticated structures, and the trust stands out very much for its flexibility, confidentiality, and various other reasons that we can go into. And I think it's also because more and more people are reading about family disputes that are being reported increasingly in the news, and they are recognizing that lack of succession and estate planning is one of the leading causes for those family disputes, which they want to avoid and therefore think about trust structures.
Yeah, you've raised a very important point. And so therefore, let me get into some of these details. When you compare them with a will, what are the pros and cons of going? So the way I see it, before we get into that, the way I see it, Yashasvi, when I'm talking about distribution of wealth, you have a few options in front of you. One, you don't write a will and you don't make it clear, in which case your legal heirs have equal right to the property that you had, and this is a normal case, right? And it is your nominee, in whatever case you've made a nominee, is responsible for the distribution of that wealth. In the event that so that's the first option. The second option is you've written a will and you've directed where you want your assets to be distributed, and so that is the second option. The third option is you have a trust structure where all of your assets are transferred to the trust, and then you've left rules that you want to be followed for the distribution of your asset. Is there anything else that is there?
I think that's broadly the framework of how we would look at succession planning and moving on assets to the next generation. Of course, there are some people who will just gift away those assets and not create a trust and just give them to the next generation to avoid any will-related issues. But broadly, what you've summarized are the three sort of scenarios that we would look at.
Yeah, I actually forgot about that fourth option because somebody told me a little while back, and this seemed like a pretty smart thing to do, but there are tax implications. We'll get to that in just a bit. But so therefore, in relation to a trust versus a will, because it's never a good idea to not have a will or not have a plan for distribution. So let's assume that that is the case, and let's not talk about that. Between a will and a trust, what stands out about a trust which is making people choose it?
It depends on certain factors, Alex. So I think let's take business families and non-business families as two groups because the considerations and objectives are slightly different. When I say business families, I mean families having some sort of family business. One of the most important aspects for them for using a trust structure is their ability to consolidate the holding of the business. So let's assume there is, say Mr. X, who is the promoter of this family business, holds 75% shareholding in the company. That person, if he makes a will, he could pass it on, of course, to his next generation. If he doesn't make a will, like you said, it gets divided amongst various heirs. Over time, you can't control how someone makes a will. So there is a risk that some assets and shares may go out of the family. There is also a risk that a person may not make a will and the shares get fragmented. And so the 75% holding, or it could be 100% holding, that gets fragmented and divided over time. Whereas if you put the shares in a trust structure, then they stay unified and consolidated, and have far more power as a controlling stake for the business family. The other reason we have seen business families use this is for asset protection and ring fencing to an extent, especially for businesses that are in risky sectors. Apart from this, apart from, say, business families, there are other uses as well. One of these is, and this is a very important point that you've touched on, is that you can avoid challenges to a will if you move the assets in a trust. Once they sit in a trust, they're out of your estate. And so if someone were to challenge your will later, and as we know that the Indian legal system is such that if there is a will and it's challenged, then that challenge could go on for 20, 25 years, and those assets stay in abeyance. Putting the assets in a trust avoids that. It also avoids probate, where probate may be required. So that remains a very, you safeguard the assets from those risks, which is very important. If there are dependent members of the family, there could be elderly, there could be minors, there could be other dependents who may have some sort of form of disability. Trusts are a great option for them because they can't hold those assets. They may not be in a position to hold those assets and enjoy them. By putting them in a trust, you're giving them to someone else and instructing that someone else that please use the income for the benefit of my dependents. And increasingly, we have seen trusts used for families where a family member is abroad, especially in the US, because there could be some tax benefits in those jurisdictions, like avoidance of estate tax legitimately.
Interesting. Okay. And so this is all from the perspective broadly of business families, people who own businesses and want to protect the ownership and the ethic or the ethos or the principles of that business. If it goes to outside hands, you can't guarantee that, and so therefore there's a trust structure. But from an individual standpoint, assuming that they have managed over a period of time to accumulate a sizable amount of wealth, does it still make sense?
For the last three reasons that I mentioned, it makes sense for the last three reasons. One is, like I said, you avoid challenges to wills and probates. You could have a dependent you could do this for and just pass on the assets seamlessly. Or you can have, sort of foreign tax reasons. These are some of the key reasons. There could also be other ring fencing and asset protection benefits that they are seeking. And that could be a good reason as well. Okay. There has to be a cost-benefit analysis, though.
So yeah, and let's come to it, therefore, cost-benefit analysis. Because there are costs associated with setting up a trust. Is it easy to set up or is it costly? Can the average layperson pick it up and do a trust structure?
Look, there is definitely a cost associated with creating a trust structure, and it's definitely more costly than doing nothing and keeping those assets in your individual names. When we say create a trust structure, we think of costs. There are 5 costs essentially that we're thinking of. One is income tax. If you create a trust for the benefit of relatives, there is no income tax, so which is great. But if someone were to say that I want to create this and include someone who doesn't fall within the definition of relatives under, so the Income Tax Act, there could be income tax there. There is stamp duty and registration costs that we need to think of when we are moving real estate. So immovable property, for instance, into this trust. The third thing is drafting of the trust deed. So this is a mistake that some people make, to imagine that a trust is, it's a cookie cutter document. It isn't. It's a very flexible document. It is customizable. A will, for example, will be about 5 to 10 pages. A trust deed runs from 25 to 50 pages. So you can imagine the complexity and the flexibilities that we can include in that document. So there you need to engage someone who's a specialist in that subject. And there, of course, there will be costs in drafting that document. Once the document itself, once the trust deed is signed, there will be some minor costs on getting the PAN card, the TAN, etc. And then there are the running costs. So you could have a professional trustee. There are professional trustees in the market. If you engage one of them, you have to pay their costs. Those could be one-time fees as well as running costs basis the assets under management. And if you don't have a professional trustee, then of course you have to run the trust. You need to maintain separate accounts. A trust has a separate PAN card. You need to file separate tax returns. You will need someone to manage the records of the trust. It's akin to a company. If you have a company, you have to have a secretary to do some of these similar things. It's kind of like that. It also really depends on how much complexity you want to create in that trust structure itself and what assets you want to put. But these are all of the cost factors that someone needs to think about. And in some cases, it might run into a few lakhs.
Yeah, so therefore, I've got my answer there. Now, if I want absolute clarity, therefore, I thought that this idea of being able to transfer assets while you're still alive has quite a lot of benefits associated. Of course, one can argue that in your old age you want to safeguard yourself and you don't want to be kicked out of your own home. That's the worst thing that can possibly happen. But I've been told that there is also the option, if you are doing a transfer deed, that you can make a stipulation in that transfer deed that you have the right to occupy the property, especially with physical assets, while you are still alive. So would you say that between a will and transferring assets to ensure that it goes to the person that you want to give it to, is the latter is a better idea?
Again, there are 3-4 aspects that we need to consider. Gifting can be a good option because, like we've discussed, you avoid wills, you avoid challenges to wills, you avoid probate, etc. But there is a cost associated with moving immovable property. Say there's an apartment you live in, and when you transfer that, there could be stamp duty. Stamp duty varies from state to state. It could be as little low as 200 bucks, 200 rupees if it's to a family member, and it could go up to a few percentages points. So that's one of the very relevant factors that we need to think about in terms of what are the costs associated. But the most important thing, and that's something you alluded to at the beginning, is control. How comfortable is a person ceding control over a property that they're living in? You're absolutely right. I think there are 2 conditions we can build into the document, the gift deed. One is to say that I will continue to have the right. And 2 is, and this is actually a development that has occurred some years ago under the Senior Citizens Act. So the Senior Citizens Act allows people who are above 60 years old, that those are classified as senior citizens, to include a clause in the gift deed that the person they're gifting it to has to take care of them and their maintenance and lifestyle needs. And if that person doesn't do that, then the senior citizen can go to the tribunal, it's called the maintenance tribunal, and ask for the gift deed to be struck off. And there is jurisprudence on this. There have been some cases where the maintenance tribunal has actually done this, and they have evicted the family member who was not taking care of the senior citizen. So this remains an option. But there is a large part of this is actually also emotion and comfort. And not everyone may be comfortable or have that emotional sort of strength to actually give it up. And I understand that.
No, it's an important point. And I wasn't aware of the last point that you raised. So it's an important statement that you've just made and information that you've given us. The last question that I will ask you, and this is something that I think is beneficial to anybody watching, right? Which is that if you are making a will, and it's a great idea to do that, just to have a sense of what you want to do with your assets, and of course your dependents should ideally know. They shouldn't have to come and have a conversation with you and say, when you're writing a will, it can have all the wrong ramifications and misunderstandings. So therefore, from that perspective, what is the checklist that you would follow?
So, Alex, first, when I say this, let me just caveat this by saying that whenever we speak about wills in India, most of the things I'm going to say will be true for most of the population. But there are some differences. For instance, if there are any Muslim viewers, please bear in mind that Muslims can only will away 1/3 of their estate without consent of their heirs. So that's a completely different consideration, and they should take legal advice for that. But generally, I think the checklist to follow, most importantly, is create an inventory and asset register. That is step number 1. Because if you don't know where your assets are, and after you, if your family members don't know where your assets are, then they will be running pillar to post just to understand what your estate was. So first recommendation is make an inventory, make an asset register. Second recommendation is have a nominee for each of those assets where it's possible to do that. The third thing is once you've made that inventory and asset, then think about who you're going to bequeath those assets to and make that will. In the will, identify people who are trustworthy and who will give effect to your wishes. Those are those executors, and inform the executors that they are the executors, because we don't want them to come across at a later date that they're the executors and may not want to act and relinquish their post. Another very important point, and not many people know this, is for people who have minor children, they can appoint guardians for their minor children under the will. So that is definitely recommended. Please write that in that will document. You can, of course, then, once your will is drafted, you print it out, you have 2 witnesses sign it, you sign in front of the witnesses. Then another very relevant point, like you mentioned, Alex, is you may not want to tell the family members, but at least tell the executor where that will is stored. So if that will is, for instance, stored in a bank locker or a personal locker, but if your family members or your executor doesn't know what is the passcode to access that, then that's going to be a problem. So let them know, inform them, and inform them how to get access to that will as well. And once all of this is done, bear in mind to review the will periodically, and not just the will. Any other sort of structure that you've created, whether even if it's a trust structure, review it periodically for changes in your assets, for births in the family, demises in the family, because all our conditions change from time to time, and all of this documentation needs to reflect that.
Yeah. Shashavi, very clear thought process and ability to communicate as well. I appreciate that. And I also appreciate that you've been polite enough to not remark on my calling your name wrong through this conversation. Thank you so much for taking the time. I appreciate it.
Appreciate it. Thank you so much, Alex. Thank you for calling me.